the lawyer, always the lawyer gets to be blamed, but sometimes it's on the instructions of the client that we need to do our job.
So I think you are very strategic inside code and outside code. After this episode, arbitrators, judges, lawyers, clients all will be happy with you with the answers that you have given. Hello and welcome to the fourth episode of the ArbCast podcast. The last three episodes have been very enjoyable and insightful, and I'm certain that in the next 6 to 8 months, with the type of distinguished guests that I have on topics which are very relevant to today's time, obviously in the arbitration world, we'll add even more insight to our listeners and our audience. For this one, we are joined with Mr. Vaibhav Mishra. Vaibhav Mishra is a commercial disputes lawyer. He practices primarily in the courts of India, specifically Supreme Court of India, Delhi High Court, NCLT, NCLAT, Arbitration Tribunals, Delhi District Courts, and he's also the advocate on record. He completed his law from Campus Law School, Delhi University, and he is at the forefront of a lot of issues which are personal to him, a lot of causes that he stands by, which makes him a very opinionated individual, which is of great relevance for the topic that we'll be discussing today, which is whether arbitrator appointments are as per the Arbitration Act. Should there be more regulation, or what are the repercussions once an arbitrator has been deemed negligent? This comes a couple of months after the former Chief Justice of India was busted for his arbitral award in the Singapore Court of Appeal for copy pasting his prior arbitral awards. This is a gloss case of negligence, and this has ignited the resurgence of a particular debate, which is why aren't arbitrators being accountable for the type of work that they're providing to an arbitration? Because at the end of the day, an arbitrator is nobody but a service provider. So we will not be specifically dwelling onto that case. There are better forums for that, but we'll be talking about the way forward, the what should be done, and what is causing such negligence by such arbitrators who have been a former Chief Justice of India. And so, with that in mind, I would like to thank Mr. Vaibhav Mishra for taking out time on a weekend and being here. So, thank you so much, sir, and I look forward to a discussion.
Thank you so much, Adit, for inviting me on your podcast, and it's a pleasure. And seeing you grow from as one of your judges in a moot court competition, and seeing you have your own platform is a great sight to see. And all my best wishes to your platform and to your podcast. So yeah, let me know when should we start with the questions on this issue.
Yes, yes. So just for some context for our viewers and audience, a couple of years ago, I had the good fortune of appearing before Vaibhav Mishra sir in a moot court competition, national moot court competition in Pune, and it was a lovely sight because he was being appointed as a judge multiple times, time and time again. And thank you, sir, for being appointed because it helped us advance to the later rounds. Eventually, we won the competition, and since then we have been in touch, and since then Vaibhav Mishra sir has been supporting me in all my endeavors, including this one. So thank you, sir, acknowledging that and pointing it out to our audience. So to begin with the first question, which is, um, there are different types of dispute resolution mechanism. One is the default mechanism, which is litigation. Nowadays, we have the mediation bill, which is in process of becoming an act, and then there is arbitration. There are critiques of arbitration who say that this should not be opted to resolve dispute because even if it is efficient, even for whatever benefit, because there is no faith in the arbitration, even though we have standards and we have regulations in the Arbitration Act from section 12 to 14. Still, it says in practice, there's not faith in arbitration. You cannot really rely on arbitrators, etc., etc., despite how the procedure has been laid out over the years. So, in your view, what accounts for this perceived lack of quality and faith? Do you think it is genuine or this is just jealousy towards arbitration?
I really don't think it's that big of a deal, frankly speaking. In a three-member tribunal, of course, there might be one person biased towards one party, the other person biased to another party, but there's a third person as well. So even if an award is given in a three-member arbitral tribunal, it will be dependent on the facts of the case and the law laid out. even if someone is biased, he or she has to give a grounds and reasons for his or her award against a particular party, whether it's the claimant or the respondent. So I don't think it's that much of an issue, because anyway, people appeal against that in the section 34 stage.
Hmm.
So it'll get stayed immediately even if there is biasness. You
Hmm.
cannot stop that even if you assume that is happening day in and day out. I don't think it happens that much as much of a fuss. It might look like that, but can you say that it doesn't happen at the high court level? Can you say that that doesn't happen at the trial court level in civil
Yeah.
disputes
Yeah.
or at other forums?
Hmm.
It's there.
Hmm.
It's. I mean, you'll find all kind of people in different sectors. So why just blame specific sector like the arbitration itself?
Maybe.
Even if a single arbitral arbitrator bench tribunal is there, where there's only one member, and if one of the parties feel he or she is biased, that one member still has to give grounds for dismissal or allowing a claim, and that grounds would be at length. So the award would not be a 2 page award or a 5 page award. It would be a 50, 60 page award or maybe 100, 150 page award.
So for anybody who's saying that only in arbitration you have cases of corruption and bribery and all that stuff, I think they're probably not following up the news. Uh, Moving on to the second question. It is often in India the norm is that you want to appoint retired judges as arbitrators. And some of these judges, when they were judges, were in the criminal side or probably not even in commercial law practice. So it's not, they do not really have the subject matter expertise. The only reason that they are being appointed is for the past credentials. Recently, Vice President Jagdeep Dhankal has encouraged looking beyond retired judges for appointment. So my question would be that why in India that this norm was developed that only retired judges will be appointed, and do you think that this should change, and how can it be changed?
Now, even practicing lawyers are appointed, Hardit. So there are many practicing lawyers I know who are appointed as arbitrators, and even not just retired, not just of the age group of senior advocates or retired high court judges or session court judges or district court judges. Even someone who's like in their 40s are appointed as arbitrators. I've seen that it's happening
Yeah.
at the Supreme Court level or even at the High Court. So young arbitrators are being appointed. And another way to get appointed as an arbitrator is that you become member of DAC. That's in Delhi International Arbitration Center. In Mumbai also there is, I think, a
MCI.
center for arbitration. Yes. So, I mean, you can be members of these centers, and if the matter is there, you can be appointed irrespective of your age or your experience. Regarding why only, yeah, you're right in that sense that there is specific preference given to a retired
Yeah.
High Court judge or a retired Supreme Court judge. There's a reason for that. I'll tell you why. The experience matters in such disputes because you need at the end of the day a person who's seen lots of matters. He or she has seen what kind of parties come across in such disputes and how they act, how they behave, what are the claim file, what are the counter claim file. Specifically, when it's a high stake matter. Say, for example, a 500 crore dispute between parties, 1,000 crore dispute between parties. Uh, there is some arbitration clause in between MNCs, foreign MNCs, and an Indian MNC and a foreign MNC. Uh, you need an experienced person to be an arbitrator there. A retired High Court judge or a retired Supreme Court judge or a three-member panel tribunal of different judges would actually work out in such cases. Because
So, I think the summary observation of that particular answer is that it is not that only retired judges are getting appointed. There are other people of other credentials, but in high stake matters, they are preferred by parties because of their vast experience. So, staying on the topic of retired
not
judges,
by parties, by the court appointing the High Court judges, Supreme Court judges. Most of the time, I'm giving a very practical answer. Say the parties give each other names of the arbitrator who they want to appoint. Most 99% of the time, they do not agree to the arbitrator to be appointed. Then they go to the court under Section 11, sub clause 6 for appointment of arbitrator. Then it's the High Court or the Supreme Court who appoints an arbitrator. Most of the time, a High Court judge or Supreme Court judge, former High Court judge, Supreme Court judge. Then they decide on the stakes of the matter that a experienced person is required. But having said that, I'm sure there must be instances where a practicing lawyer is also appointed by the High Court or the Supreme Court.
yeah, yeah, noted. But staying on the topic of retired judges, there was a retired judge who went by the name of Chief Justice Deepak Mishra. who recently was in the news for copy pasting verbatim paragraphs from his earlier arbitral award in his recent arbitral award. And it was an embarrassing moment because the Singapore Court of Appeal held that this was a breach of natural justice and showed apparent bias and undermined tribunal deliberation. And it also does not indicate that the arbitration award was well reasoned, because if it was, you wouldn't copy paste from another award, which is not of this particular case. So we are not going to go into that particular case as to why that happened and gossip about it. But after hearing, after, you must have been aware of this news. Like, what was your, how did you perceive it? What message does it give out to the parties, arbitrators, and how it's actually going to affect the faith in the process of arbitration to our clients?
Regarding this particular case, I haven't seen the facts or the exact award and how it was upheld or dismissed by the Supreme or the I think Singapore Supreme Court. So it won't be right for me to comment. And Justice Deepak Mishra has been the Chief Justice of India, so it won't be right to comment on him personally. Be that as it may, mm, I mean, how do you define copy paste? Is that
Yeah,
that is even a relevant question? How do you define
indeed,
copy paste?
indeed.
Yeah,
So,
if I'm researching for a particular on an issue and I'm drafting, then I'm of course copying pasting someone's judgment. So, for example, if I'm mentioning it in my footnote or in my in the end also if I'm mentioning a particular judgment, of course I'm copy pasting it. But how do I use that in my draft is up to me. Whether I
mm,
use the exact verbatim or do I paraphrase that is up to me.
mm,
And then
indeed.
how is that interpreted? Again, I'm repeating myself that I haven't seen the award, nor have I seen the Singapore Supreme Court judgment. But tell me one thing: if you are making drafting an award, so example, you are even drafting a plaint or a suit or a reply or a note, and you have to rely on other research stuff. You will of course paste it, but it's up to you how do you paraphrase it or how you use the exact verbatim, and then you define it on how the analogy or the context is relevant to the case at hand. Now, what Justice Deepak Mishra did or did not do, I don't know, and I am at no power to comment on him personally or the award which he had given. Nor am I at power to comment on what the Supreme Court of Singapore, I believe it's the Supreme Court of Singapore,
Court of Appeal.
subject to correction,
Yeah.
okay, Court of Appeals, has said, and what were the grounds for it to see that it was copy pasted?
Mm,
Was it the entire award copy pasted? I don't think so. That an entire award would be copy pasted in another award. Some paragraphs copy pasted. Okay. Were footnotes used? I don't know. If they were not used, then of course, then there is plagiarism, and I mean it's not fair and right, which was done by the learned tribunal.
mm,
But like I said, I don't know. Now, we won't be at the right stage to comment on that. But
yeah.
like I said, copy paste is a very how do you define copy paste is another question. Every lawyer copies someone else's research in the sense that someone else's judgment and uses it in his or her context, paraphrases it and then mentions it in the footnote. Do you define that as a copy paste? It's an open interpretation. It's a subjective interpretation. Do you just use the exact verbatim and then define it? Then you've applied your mind. There's an application of mind by you. So, but some people would still call that also copy paste. Maybe one doesn't know.
Yeah.
So it's not it's a very open-ended question on how do you define copy pasting it. I'm sure the learned judge did not copy the entire award and then paste it in the entire award in which he was writing on, and then gave only 2 3 paragraphs of his own, and then said, "I am done. It's the best award which I've given." I'm sure it must be more to that. And because he's been the Chief Justice of India, I'm sure he must have applied his mind somewhere or the other. And whether it's still upheld by the courts of appeal in Singapore, I don't know. I'm sure Justice Deepak Mishra should have gone into appeal or should have done something about it. It's damaging his I mean his name if it's still going on like that. So must have been something about that.
I think that is a very nuanced answer that Vaibhav sir just gave, because as you would know, when this news broke out all over social media, people jumped the gun and started blaming the judge, but they didn't really question actually what happened. Was it like a copy pasting of quotations of actual other judgments, or counsel's submissions, something like that, which can be copy pasted, or was it that the ratio that was copy pasted? And he posed me a question as to what was copy pasted, and we do not know because the award is confidential. So we actually don't know actually what was copy pasted. So it is important that as Indians also that we do not jump the gun and just say that a former Chief Justice of India is so incompetent that he cannot draft an award himself. And I think that that's a nuanced approach and a thought perspective which I never thought about it before. I also was in that group who jumped the gun, started blaming the judge and passing comments and whatnot like the regular group of people. But that's actually good, and different, insightful answer on this particular question. And to be the final question. So we have spoken a lot about appointment of arbitrators and everything that is wrong in that particular process in India. But to conclude on a good note, concluding on a high note, I would like to ask Vaibhav sir, in your experience being in arbitration and seeing arbitration from in the last 10 years, how do you see the appointment process has changed? Has it been better as compared to what it was, especially after 2015 amendment, 2019 amendment, and even the 2021 amendment, even though that was not concerning the arbitrator appointment? But the question being, how has it changed? What are the good aspects of appointment of arbitrator in this jurisdiction as compared to other jurisdictions in Asia and around the world?
We haven't just discussed the negative things, we've discussed some good things also, Hardit, about the arbitration law. We just said that how things can improve and what is the practical aspects when one does arbitration. So, I mean, it's a very complex structure, even arbitration law. Although it was not initiated to be such complex, but bearing the nature of litigation it's involved in, arbitration law has been a bit complex. But having said that, like I said in the initial answers to your questions, to the issues at hand, the time consumed by arbitration in India is still a bit less from what I see as compared to a general litigation in India, say a civil dispute from a trial court to a Supreme Court. Coming to the question at hand, that whether foreign uh, jurisprudence regarding arbitration law, how it is per se to Indian arbitration law, I think there's a lot of catching up to do by India. If you go to SIAC, Singapore International Arbitration Center, you'll see the way arbitration is conducted there and how quickly it's conducted there. And I mean, you don't, from what I haven't been to SIAC or Singapore arbitration centers for arbitration matters. From what I've heard is that they don't spend too much time in the mechanism. Like I think specific dates are given, specific time is allotted for arguments, and whatever you want to say, you say that. You can't keep arguing for days and days and days and days. In India, also, like I was involved in a recent arbitration. The award is now reserved, I think. I was involved. Specific dates were given. 2 days to the claimant to argue, 2 to 3 dates to the respondent to argue. Any rebuttal, then you do that. But then you have to stay the whole day from 10 in the morning or 11 in the morning till about 5 in the evening. So you stay like that during the whole process. So I think we are being professional regarding that sense, but I think there's a lot of catching up to do. There's a reason why foreign MNCs choose Singapore or London as arbitration seats of arbitration or centers for arbitration to resolve their disputes. Maybe not at Delhi or Mumbai as of now. So I think we need to look into that. At what is the reason? Is it the time taking process? Maybe not. Is it the appellate process? Maybe, maybe not. Is it the time taken out in the execution process or in the stay process? There's a recent, I think, subject to correction. There's a recent, I think, Amazon dispute where a stay was given from Singapore. Then the parties rushed to, one of the parties went to Singapore to get a stay. Then one of the parties went in India and moved an arbitration or went to the court in India. There was international dispute on regarding jurisdiction as well. So why would a party still go to Singapore? Was it there in the seat of arbitration clause in the contract, or was it some other reason? Why wasn't the dispute still resolved if one of the parties were an Indian party and the other party was a foreign party? Why didn't the foreign MNC have faith to be in India and resolve the dispute in India itself? That's a question which is for all of us actually to understand and to address. That how can we improve the mechanism? Is it only the time taking process? Is it the appointment of arbitrator? Is it the quality of arbitrators? Is it the quality of counsels in India? Could that be an issue? I mean,
Yeah.
that's the bigger question. That's a question which someone might not want to even answer. That is it the quality of counsel, quality of arbitrators involved in India? Is that the reason? I don't know. So it's a question for all of us to understand why would keep international MNCs still choose Singapore or London and not Delhi or Mumbai. So to improve on that front, you can have thousands of amendments in the Arbitration Act, but that will not be lucrative enough for a foreign MNC to choose Delhi or Mumbai as seat of arbitration. You have to streamline the process at the arbitration stage. You have done that already. Maybe more streamlining may be required. You have to streamline the process at the appellate stage, at the High Court level or Supreme Court level as well. And you have to streamline the executions level as well. How do you execute the arbitral award? That's a big question. So, and these are the things you need to see. And the quality of arbitrator, the quality of counsel, I don't wish to comment on that, but whether that is the reason or not, that only the parties involved can answer.
Understandable,
I
no
hope not.
problem.
I really hope not, because I do believe there are good enough quality arbitrators in India and good enough quality counsels in India. I'm no one to comment on them.
Very
So that's what I'm saying. I
diplomatic,
hope not.
very diplomatic answers, if I may say so. But I completely understand, and I think there's one aspect that we should all take away from this episode, which is Vaibhav sir said that certainly that India is lagging behind, but we cannot always pinpoint fingers to arbitration. Pinpoint fingers to arbitrators or the law. Perhaps the law is what it should be. Let's not forget that this law is based on the unstrict trial model law, which even advanced jurisdictions like UK have not adopted. So we are in law. I don't think that there needs to be done any further changes because it already is there. But the issue is that is it being enforced the way the law envisages? And then the fingers can be pointed at arbitrators or even councils, which people don't usually talk about. How many times councils delay? How many times do council after an award has been rendered purposefully file at Section 34 application, even though they themselves know that there is no merit in that application, but they will file it just for the sake of delaying it, which they know is contrary to the intent of the act. So it is also the responsibility of the council as much as the arbitrator to ensure that the intent of the act is upheld and don't file frivolous claims in court or in arbitration tribunal just to delay the tactic because that is not what the arbitration tribunal is all about. So on that note, I think we had a very lovely
Don't
conversation.
blame the don't blame the councils too much. Also, Hardit. Sometimes clients want to file that, and it's the clients who are more to be blamed actually for filing an appeal and staying the award, even if that's not to be appealed. Sometimes the parties themselves wants to file it. You can't blame if one council will not file it by saying that it's not maintainable. The party will find another council. So it's the
So
parties involved also who wants to file
that's
the. So it's not the lawyer. Always the lawyer gets to be blamed, but sometimes it's on the instructions of the client that we need to do our job also. Plus, we need to earn our bread and butter also as well.
So I think you are very strategic inside code and outside code. After this episode, arbitrators, judges, lawyers, clients all will be happy with you with the answers that you have given. But on that note, sir, it has been a very lovely conversation. I want to thank you for always supporting me in my endeavors. I'm sure you will continue to do so. And I hope the audience enjoyed listening to our conversation. We will have such conversations on different topics, but in arbitration and commercial law only in times to come. So do keep an eye out. And thank you so much, sir, for being here.
Thank you, Adit. Best wishes and best of luck.